I'm not going to disrupt that adoption because some crazy lady has some crazy theories.
My parental rights were illegally terminated. It doesn't matter how you cut the cheese, simply because my husband at the time was accused of a crime. You cannot, under Texas state law, terminate parental rights on someone else's accusations.
Was Lesnar children, not Lester anymore. Before we get started, Mr. Hill, you represented Miss Lester originally, correct?
Judge, I did, and then she opted to represent herself,
Okay.
if memory serves me correctly, and you left me on as standby counsel.
All right. So for purposes of today's hearing, Miss Lester is now treated as a kinship, so she's not entitled to a court-appointed attorney. So you're not bound to stick around if you'd like to go. I felt like I had to notify everybody just so if anybody had any information that the court thought it should hear, that's why you're here, but you're not bound to stay here.
Judge, I'm here. I might as well stick around.
Okay. All right. Okay. You won't be asked to participate unless you're called as a witness. So, okay. Thank you for showing up.
Yes, sir.
I will call the case again. We've talked about Mr. Hill, why he's here. Ms. Surratt is here representing the department. Mr. Nowak is here representing the children. He was appointed for purposes of this hearing as required by the statute. And again, Ms. Lesnar is with us. Before we get started, Ms. Surratt, you had a motion to dismiss. Did you have any exhibits you wanted to introduce? I think we can take up that motion to dismiss first because I think it's going to be dispositive of today's hearing.
Yes, Your Honor. I sent out exhibits 1 through 4 or 5 to the parties. I sent that out yesterday, and I would move to admit petitioners exhibits 1 through 5. As far as the motion to dismiss, it is a bar to filing the reinstatement of parental rights under 161.302 B3 if the children have been adopted, and these 4 girls have been adopted, and that's in petitioner's exhibit number 1.
Ms. Lesnar, do you have any response to that?
I don't know why I was muted, but I would object to allowing the state to have a dismissal knowing that my parental rights were illegally terminated. It doesn't matter how you cut the cheese on the rights terminated. The state asked the jury to terminate my parental rights simply because my husband at the time was accused of a crime. You cannot, under Texas state law, terminate parental rights on someone else's accusations. They had to find some kind of lawful reason to have me terminated from my parental rights, and they did not. The state has made those claims, and I have taken it up with the Department of Family and Protective Services in the commissioner's office. And they are the ones who told me there were no findings of guilt on my part, and I should have my children. Jerome Green stated that I should have possession of my daughters back in 2020 and asked me if they were at my house. And I told him, no, they were not.
Ms. Lesnar, let me interrupt you. Your rights were terminated. From what I read, that went to the 7th Court. Excuse me, don't interrupt me. That went to the 7th Court of Appeals, and it was affirmed on November 26th of 2018. A petition for review was denied by the Texas Supreme Court. On June 3rd of 2019, the mandate issued. So your rights are terminated. And if you don't understand what Ms. Surratt was saying, the statute that allows you to ask for reinstatement of your parental rights, you must prove to the court that the children have not been adopted and the children are not subject to an adoption placement agreement. Plus, you have to have given notice 45 days prior to filing your petition to the department. These exhibits that have just been admitted show that the children have been adopted, and they show that you did not give 45 days notice of the filing of the petition prior to filing it. You gave the notice on the same day that you filed the petition.
No, sir, I did not. Well, I gave that notice in December, and I have proof of that.
According to the exhibit, let me interrupt you. The children are adopted. Unless you can convince this court today that the children have not been adopted, I have no choice but to dismiss the case. That is a prerequisite to you to even file the petition.
They were adopted illegally.
Okay,
What do you
that's
want
not
me
what
to
the statute
say
says.
about the illegal part of terminating my rights?
That is not
Does
what the
not the
statute
state
says,
of
ma'am.
Texas say that they support fundamental law? If the state of Texas does not support fundamental law, then I wouldn't be arguing the fact that the adoption was done illegally. They never found a basis to terminate my parental rights. I
I'm
asked.
sorry, I'm going to interrupt you one more time. The statute says you cannot file that, or it'll be dismissed if the children have been adopted. It doesn't say that the children have been legally adopted or illegally adopted.
So you're saying an illegal action can be done in a court?
I'm saying what I just said. The statute says if the children have been adopted, then I have to dismiss your petition for reinstatement, and that's where I'm standing. So that's my intent today.
If you dismiss this, Judge Graham, Associate Judge Graham, I should be seeing a judge who has standing. You are an associate judge. You are just a lawyer. Do you understand that you right now are violating my constitutional rights as you did 8 years ago?
No, ma'am, I don't. So again, unless you can present evidence that the children have not been adopted, I'm going to dismiss the case right now without any further testimony because the exhibits that have been admitted show that the children have been adopted.
And the other exhibits stating that I did not file are not proving that I did file 45 days. That's not the state lying right there.
Petitioner's Exhibit 2 is a certified copy of your notice of intent to file this petition. It was filed on March 14th, 2025 at 8:51 a.m. Your actual petition for reinstatement was filed on March 14th, 2025 at 8:51 a.m. So yes.
That is incorrect.
Well,
On
that's
December 30th.
You can take that up with, excuse me, you can take that up with the district clerk because they have certified that these are accurate records. So, Mr. Noaklep, you want to weigh in on this? You represent the children. Do you have recommendations for the motion today?
I do, Judge, and I so appreciate your temperament and your patience. Mom's rights were terminated. The kids were adopted. I'm not going to disrupt that adoption because some crazy lady has some crazy theories.
Excuse me?
I apologize for that, Judge. My recommendation to the court today is to dismiss whatever mom has filed. And Judge, I do apologize for my commentary earlier.
That's fine. Okay.
It may be fine to you, but that's defamation of character, Judge.
Well, you know what? I'll defame your character all day long, lady. Judge, that's all I've got.
Ms. Lesner, the court finds.
Judge, can I confirm something real quick,
Sure.
Judge? Did you admit
I
my
haven't.
five
No.
exhibits?
Are there objections to 1 through 5?
And I named them departments, exhibit 1 through 5, since I guess Mrs. Lesner is actually the petitioner in this particular situation.
Well,
No objection, Judge.
All right, petitions
course
1 through 5 are admitted. The court finds that based on department's exhibit number 1, that the children were adopted
Illegally, under the table. I never got the adoption papers because they knew back in the day I would have argued that till the cows.
I'm getting ready to mute you if you interrupt me one more time.
Oh, but you can interrupt me, right?
The order granting adoption was signed. It's in cause number 78010-L1 in the county court at law number 1. That order was signed by Judge Anderson on June 10th, 2020. And I'm looking at a certified copy of it under Department's Exhibit 1. Court finds that Ms. Lesner has not met the basic requirements to go forward with this petition because the children have been adopted. Therefore, I'm going to grant the motion to dismiss. All right, Ms. Lesner, you have 3 days, working days from today to file a de novo if you'd like for Judge Anderson to rehear this case. You have 20 days after I sign the judgment when it's presented to me to appeal this to the Court of Appeals. You understand that?
I'll see you in federal court.
I'll see you then. All right.
Good. All of you.
This was our last hearing for the day, so we'll stand in recess. Everybody have a good weekend.
You too. Thank you.
Good
Judge,
to see you.
it's always good to end my week with you. You have a wonderful weekend, my friend.
Well,
Thank you so much.
It's usually interesting on Fridays. I'll give you that.
This one
It's
was
nice to
different.
see how much you all know each other and are so.
Y'all have a good weekend.
You too,
Thank you,
sir.
Judge.
Thanks, Amy.
Thank you, Judge.
Cases like this show how final adoption orders create legal closure. Once parental rights are terminated and an adoption is finalized, the law sets very narrow limits on reopening that door, even years later. Reinstatement statutes exist, but they're strictly written. If a child has already been adopted, Courts are bound to protect that permanency. No matter how strongly a parent disagrees with the past ruling, judges must apply the statute as it's written. If you appreciate real, courtroom breakdowns explained in plain language, be sure to subscribe to the channel so you don't miss future cases.